Distressed companies face a tug of war in trying to retain talent through retention and incentive plans, while at the same time satisfying the Bankruptcy Code standards for such plans. The same applies to severance plans. Meanwhile, the company's executives are also exposed to losing out on non-qualified deferred compensation payments and supplemental executive retirement plan benefits that they may have been counting on. The rationale for key employee retention plans and key employee incentive plans is clear enough. Avoid a brain drain, keep institutional knowledge, and protect client relationships, all of which may be essential to coming out of a bankruptcy or presenting a viable target for acquisition. But Section 503C of the Bankruptcy Code was enacted to prevent abuse in these pay-to-stay plans by subjecting key employee retention plans for insiders, as well as severance payments, to approval requirements under Section 503C. Insiders for these purposes include any officer, director, general partner, or person in control, or someone in a similar capacity, regardless of title. In order to obtain approval for a key employee retention plan, its primary purpose must be to induce the insider to remain with the company, and the company must establish, first, that the plan is needed to retain an insider who has a bona fide offer for another job with comparable pay, second, that the insider's services are essential to the company's survival, and third, that the payments to the insider are within certain limits relative to non-management employees. For key employee incentive plans under Section 503C, the company must demonstrate its link to added value instead of being just a retention tool. That is, pay for value rather than just pay to stay. Satisfying the requirements for key employee retention plans and key employee incentive plans is achievable in most cases, but expert guidance would help avoid missteps. On the other hand, pre-petition bonuses to executives currently are not subject to limitations under the Bankruptcy Code, but planning on such bonuses should be utilized to avoid upsetting the apple cart on the viability and objectives of the retention and incentive plans. Turning to a distressed company's non-qualified deferred compensation and supplemental executive retirement plans, these arrangements are, by definition, unfunded, meaning that it's an unsecured promise to pay, and any monies or accounts designated for such plans are subject to the claims of the company's creditors. If the company is insolvent, this usually results in the executives losing out entirely on their deferred compensation or supplemental benefit. For example, if assets have been placed in a so-called rabbi trust for the payment of non-qualified deferred compensation benefits, the company's secured creditors would have a priority claim ahead of the unsecured claims of the executives. Further, if the company considers any accelerated distributions from these non-qualified plans in advance of the bankruptcy, there may be adverse tax consequences under Section 409A of the Internal Revenue Code, and if there is a bankruptcy filing after the distributions, they may be vulnerable to a preference claim.